first case is State of Ohio versus Timothy Duane Christian. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Good morning, Your Honors. My name is Marie DeCola, and I represent the appellant with Attorney Jacob Will. I would like to reserve 5 minutes for rebuttal. Starting with the first assignment, which relates to the restitution portion of Mr. Christian's sentence. I don't want to spend too much time on this issue because I think it's fairly straightforward. The applicable statute is Ohio Revised Code 292971. The title of that code is Reimbursement of Investigative Costs of Arson. And this code sets forth the procedure that the trial court must follow before ordering an arsonist defendant to pay restitution to the agency who investigated the arson, in this case, the Akron Fire Department. The record is clear that the trial court did not follow that procedure. I'll note for the court that the state relies on cases for this issue that are distinguishable because they deal with restitution orders under a different statute, the General Financial Sanction Statute for felony sentencing, which is Ohio Revised Code 292918. That is not the applicable statute in this case, and those arguments should be therefore disregarded. After a plain reading of Ohio Revised Code 292971 and a review of the record in this case, it is clear that the trial court erred when it failed to follow the restitution procedure outlined in the statute, and we ask the court to reverse the trial court's restitution order accordingly. And if there's no questions on this issue, I will move on. And I'm going to address the remaining issues, assignments 2 and 3, in tandem because they're legally and factually related. In assignments 2 and 3, we argue that the trial court erred in imposing consecutive sentences, and that this error is underscored when considering the disparity between Mr. Christian's sentence and his co-defendant's sentence. Mr. Christian was sentenced to 22 to 26 years in prison. The trial court justified this sentence by conclusively stating that consecutive sentences were necessary to protect the public and punish Mr. Christian, that the sentence was not disproportionate to Mr. Christian's conduct and the danger it caused, and that no single prison term could adequately reflect the seriousness of Mr. Christian's actions. Starting from the top, the trial court erred in finding that 22 to 26 years was necessary to protect the public from Mr. Christian. His criminal record did not provide the court with a sufficient reason to sentence consecutively. His record consisted of mostly misdemeanors, some drug charges and other crimes of poverty, and 1 misdemeanor domestic violence from 2010. The trial court also erred in finding that a 22 to 26 year sentence was proportionate to Mr. Christian's conduct and the danger of that conduct. The fact that the conduct caused harm to 2 firefighters is an element of the offense of aggravated arson. The trial court improperly used an element of the offense to elevate the seriousness of the conduct during sentencing. In that same vein, Mr. Christian's conduct was not more serious or more dangerous than his co-defendants.
What do you consider crimes of poverty?
So crimes like misrepresenting identity using like a credit card that's not you're not authorized to use, driving under suspension, other drug paraphernalia, drug like misdemeanor marijuana charges, things that are not violent offenses, but that are just kind of more rudimentary and more routine for people who are in certain states or certain classes. But in the same vein, Mr. Christian's conduct was not more serious or more dangerous than his co-defendants. It was the same case, the same fire, the same victims, the same danger, and the same harm. The only difference was the alleged leadership role. The trial court believed that Mr. Christian directed his co-defendant to set the house on fire. His co-defendant then set the house on fire. Mr. Christian was not at the scene, and his co-defendant actually lit the match. Ohio law says that sentences must be proportionate with the seriousness of the conduct. Mr. Christian's conduct, his alleged leadership role, did not justify such a disproportionate sentence. Ohio law also says that sentences must be consistent with sentences for similar crimes and similar offenders. That's what the law mandates. And I understand that Prosecutor Raley is going to stand up here and tell the panel not to consider Mr. Christian's co-defendant's sentence in this case, even though it was imposed by the same court for the same crime. I think that argument is flawed, because proportionality between sentences is most accurately determined when comparing the sentences of two people involved in the same crime. No other case could be more relevant or more similar. So again, in this case, we have two offenders, two co-defendants. And according to the state, one co-defendant told the other to light a house on fire. The other co-defendant lit the house on fire. There was an explosion, firefighters were injured. These are the reasons that the court used to justify its sentence of 22 to 26 years for Mr. Christian. Decades. Because in the trial court's opinion, no single prison term would adequately reflect the seriousness of the conduct. But the trial court then contradicted itself when it sentenced Mr. Christian's co-defendant to a single prison term of 4 to 6 years.
Did Mr. Christian object to the sentence at the time?
Trial counsel did object to the consecutive sentences, yes.
And did Mr. Christian object to the restitution determination?
He did not object to the restitution determination, no. So I believe it's a plain error standard of review. The plea agreement between the parties said that restitution was to be determined, but it hadn't been prior to sentencing. So the trial court sentenced the co-defendant to 4 to 6 years. This is a flagrant disparity, and it wasn't justified. And this court cannot conduct a meaningful proportionality analysis without considering how disproportionate these two sentences were. The law's requirement that a trial court must sentence offenses and offenders consistently would have very little meaning if Mr. Christian's sentence could not be compared to that of his co-defendant.
Is there anything on the record about the co-defendant? Like, do we know any background information about the co-defendant in the record? How can we compare if we don't have that information?
Right, so we had attached the co-defendant sentencing transcript, which I believe was stricken because of the appendix requirements. I don't think there's any dispute that the co-defendant received a sentence of 4 to 6 years. The issue that I kind of faced in writing the brief was that Mr. Christian would have been unable to object to the disproportionate, nature of the sentences because the co-defendant hadn't been sentenced yet. He was sentenced after Mr. Christian. I think lastly, just to wrap up here, we argue that the trial court's findings lacked individual reasoning. Aside from Mr. Christian's alleged leadership role, the only other individual reasoning given was that Mr. Christian pled guilty, withdrew that guilty plea, and then pled guilty again. And the trial court stated that despite his 2 guilty pleas, she was not convinced that he accepted responsibility. Definitionally, he did accept responsibility when he pled guilty. The trial court's comments both before and after his guilty plea, as cited in the brief, give the appearance, at the very least, that the trial court imposed a harsher sentence on Mr. Christian, not based on his conduct, but based on the procedural posture of his case. This court has warned against this exact appearance in State v. Tucker.
Well, this wasn't a trial. I mean, he pled. So we really can't use the case law in regard to, using the fact that he went to trial against him.
Right, I think our argument is that he had pled guilty, and then there were comments made during that first plea that if he were to plead guilty on that day, he'd be given credit for accepting responsibility. Then he was permitted to withdraw that guilty plea. The trial court found that there was some hesitancy when he pled guilty the first time, and then he did subsequently enter another guilty plea. So it's our position that this delay and this wavering back and forth, whether to accept a plea or to go to trial, is what the trial court was, punishing Mr. Christian for, was the procedural posture and the delays that he caused by going back and forth about trial or a plea. So all of these errors resulted in a sentence that was clearly and convincingly contrary to the law, warranting either reversal or modification. If there's no further questions, I will reserve the rest of my time for rebuttal.
May it please the court, my name is Rick Raley. I'm appearing today on behalf of Summit County Prosecutor Elliot Kulkovich and the state of Ohio in this matter. I do want to respond to Mr. Cola's arguments this morning and kind of use the same framework as she was going through. And let's start with the first assignment of error about this restitution order issue. There were questions about the lack of an objection. There was no objection. And in fact, the statute about the fire investigation costs, I don't think that was ever raised either in the court below. What was raised in the plea agreement was there was to be a restitution order based on that, and it was supposed to be part of the sentence, and it was going to be determined. There's also an indication in the record that there was a piece of paper that the state and the defense were looking at when this number was stated in open court without objection.
When you say restitution to be determined on a plea form, doesn't that typically mean you'll have a restitution hearing?
It depends, Judge. I would say that if there was something where there's a dispute here and we're not agreeing to anything, then that's a request for a restitution hearing. If you are in a sentencing hearing and you hear from the state, this is the amount, and you stand silent, you're indicating that's what you think the evidence supports, and you think the bigger issue is about the number of years you get. So that's why I think this is a lack of objection, plain error, and there's not a plain error argument on appeal, and that's an easily disposed of assignment of error. Because of this particular issue with this being the fire investigation, I don't think this is a great vehicle for this court to look into the appropriate standard of error for restitution orders. I think it was Judge Stevenson's order from 2023 saying there is a question about that. I think we should probably stay away from that in this particular case. But I do believe there's pretty clear there's no plain error that you can find on the first assignment of error. Moving from that into a combination of the second and third assignments of error, I think that there's very clear case law that disproportionate sentences under Ohio law are based on an inconsistent application of sentencing guidelines. In order to show there's a disproportionate sentence, you have to show that the trial court failed to consider statutory sentencing factors. And the defendant cannot make that showing in this case. Consistency doesn't require uniformity. And a lot of what we're talking about this morning about there is no information in the record about what the sentence is for the co-defendant. There's no information in the record about what the co-defendant's criminal background is, what his particular circumstances are in the sentencing factors, how they would apply to him.
Counsel, how would you ever do that? How would you ever make a record?
I think under the way the Ohio case law is written, you have to show that the judge did not follow the sentencing guidelines. That's the only way to show there's disproportionate sentences.
So that's the disproportionate sentence then is no different than the standard we would use for consecutive sentences or anything else that, that the judge followed the guidelines.
Correct. That's what I would say. That's what the authority.
Doesn't that kind of like defeat the whole purpose?
Well, if that's the case, then there should be some other authority that would say we need to change how we've done things for a long time.
Well, we've had this issue for many years, and I just wondered if the legislature just didn't realize that you can't get those issues before the Court of Appeals.
That would be something that, and they certainly have seen the authority for years saying this, and they could have changed it since then. I would say, if there is a proper case with the right authority, there would have to be a significant amount of information in the record about those other cases. There'd have to be multiple other cases. I've also practiced in Lorain County. There were lawyers there who would bring up, this is the same offense in 10 other counties, and then this is the sentence they received. And still, in those circumstances, we would say, no, it's all about whether you apply the sentencing guidelines or not. That's the question. It's not a federal system point counting type sentencing guideline structure. We have a different structure in Ohio. And until that's what the legislature wants to change, that's what we are stuck with in the state.
Of course, this is, if we had record, this would be a unique situation because it is two co-defendants. And obviously, if you knew what the background was and everything.
Absolutely.
But we don't know any of that. But that's different than, because I've been on those cases in Lorain County as well, where you have 10 different, cases from 10 different counties, but you don't know what actually is going on with them.
Correct, and that's another issue with this particular case. PSI report was waived. There's no PSI in the record. There's limited factual development of the particular circumstances of these offenses and these two individuals. What you can glean from the record, though, is that yes, Mr. Cole is correct that Mr. Winchester lit the match. But it's also equally clear that Mr. Christian gave him the match and told him what to do with it. He was the one with the financial motive for this crime and that benefited from it. There are other aggravating circumstances for this defendant. He took steps to cover up his involvement in the crime. That shows a higher degree of culpability under our sentencing guidelines. And I think that it's very clear in this case that it's premeditated, deliberate behavior by Mr. Christian. He has, although you can undermine how serious his prior offenses are, he has consistent police contact for decades before he committed this crime. And I do think that it's important that this court gives value to what was heard at the sentencing hearing from one of the victims of this offense, how dramatically this offense affected that firefighter's family. So based on that, I think it's clear that there is clearly enough evidence in this record to say the trial court's findings are not clearly and convincingly contrary to law.
I have a question about an itemized statement or itemized restitution. It sounds like that was read into the record.
It was not read in.
Or referenced in the record?
There's reference to, there's a piece of paper that has cost associated. That's what I gleaned from reading that.
So is that itemized? It's referenced, but was it made part of the record?
It was not made part of it.
So there's some evidence in the record there wasn't itemized.
There was some evidence that there was a piece of paper they were looking at the sentencing hearing. I'd also just go on that. I think it's important that this court looks at the full offenses. I disagree very strongly with my opposing counsel's view that looking at the elements of the offense is not an important part of sentencing. I think that looking at the entire offense is critical to determine the correct sentence. And I believe that's what the law would require. So unless there are further questions, judges, I'd ask that you affirm the sentence in this case. Thank you.
You'll have your full 5 minutes for rebuttal.
Jumping back to the restitution issue, it's true that the prosecutor attached an itemized, or the record indicates that there was an itemized list of costs that were associated with the investigation attached as an exhibit to the sentencing memorandum. But that in and of itself does not comply with the statute. The statute says that the agency, the Akron Fire Department, has to file that itemized list and provide it to the defendant, that a hearing has to be held, and that hearing can be at sentencing, but it needs to be separate. And in that hearing, the agency has to prove by a preponderance of the evidence that those costs were incurred by that investigation. And the defendant would have an opportunity to question that agency about the costs that were derived from the investigation.
But couldn't the defendant object if they said this is the restitution, this is the itemized version, and then if there's no objection, doesn't that seem as if he's consenting to the amounts?
I don't think so, Your Honor, and I distinguish this case a bit from the Ellis case out of this court, where there was a plea agreement in the Ellis case that said, that had the specific amount that was to be owed. And in this case, we didn't have that. We just had restitution to be determined. And the prosecutor is the one that provided that. And this court has said that just because there is a plea agreement, or that the state and the defendant are jointly agreeing on the amount, that does not relieve the trial court of its responsibility to comply with the statute. I think the exact portion of that case says, while the parties' agreement or stipulation as to restitution may be considered and ordered, a trial court must still comply with what the restitution statute mandates. And that did not happen in this case. In terms of the disproportionate argument and how this court is supposed to consider both sentences without, Mr. Winchester, the co-defendant's sentence, being on the record, I don't believe that this court is required to have evidence of that sentence when it was the same trial court in the same case. The state's brief cites two cases where the defendant is arguing, well, in this county, this was the consistent sentence for this offense, or purportedly similar offenses from different counties or even from the same county. That's not what we have here. We have the same case, the same trial court. The trial court was in front of this court, was in front of the trial court in terms of the information that she had when she issued those very disproportionate sentences. So I don't think that this court is limited to what is on this record in determining that when it comes to just the disparity. I don't know how else to meaningfully ever consider if two sentences are, so disproportionate, especially in the same case. Lastly, the argument that there were more aggravating factors for Mr. Christian in terms of, steps he took to evade detection and whatnot. I could be misremembering the record, but I don't believe that the trial court relied on any of that in making its sentence. I don't believe that any of the, supplemental evidence or any evidence at all of Mr. Christian taking steps to coerce his co-defendant or to evade responsibility and detection were relied on in the trial court when she sentenced Mr. Christian to 22 to 26 years. If there's any questions? If not, I will sit down. Thank you.
The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and the opinions are posted on the Ohio Supreme Court website. Thank you both for your presentations.